that Article 3, number 1, fails to provide substantive guidance as to what is and what is not in a child's best interests. And that the vagueness of this principle opens up to the personal values of the judges to be maybe decisive. And it's not only this case, there's another case of another baby in England that was also taken off life support and then, of course, died. And judges in both of these cases decided that it would be in the child's best interests that the life support was cut off. And then the question is, how can this be? And what about the right to life in all of this? And I would like to start off by saying something about in what situations should best interests be the principle or the rule, actually, that you use to decide a case. And this is about the relationship between best interests and the rights of the child, because best interests, just to say that immediately, they don't trump rights. So if there is a right which is clear-cut, you cannot use best interests to take that right away from the child. So first, in a specific individual situation, you need to establish the rights of the child in question. Now we're all the time talking about individual situations, not about the sort of general lawmaking and so on. And then if these rights are in conflict or they don't give a clear answer, the best interests consideration comes in and may be applied, and it may be even of help, I would say. So the case of babies on life support, they do certainly have a right, as all children, a right to life under Article 6 of the Convention, which gives the right to life, but also to development. But is it correct to say that this is a right to life under all circumstances? If it comes to actively taking the child's life, maybe the answer is yes. This also goes into the big question of euthanasia, which is difficult. But then I'm talking about actively helping the child to die. When the child is given medication or other kinds of life support, if you take that away, the child will die, but it's not the same situation, I would say. I think we need to distinguish between these two situations. It's it's the passivity then. It's not giving the aid to support life that takes the child's life away. But then there might be some other rights in this situation as well. What about the right not to suffer? Is there such a right? In the Convention, you have Article 3, number 2, saying that the states should ensure the child such care as is necessary for the child's well-being. And if the child is suffering, there is no well-being for the child. Article 6 gives the right not only to life, but also to development. And in the case of Charlie Gard, there was no signs of a positive development at all. I mean, I don't know if you've read the case, but he was really, really seriously ill. And there was no hope that he would survive on the or lead any kind of life. There was no brain activities and things like that. And he might have got a kind of miraculous medical treatment in the US, which might have worked, and the doctors thought it might have worked. But then in the meantime, he got many brain seizures because he also had epilepsy, and then that's when the brain activity really, really got minimal. Just to put that for this case. And then there would not be any development that you could actually think of. He wouldn't have his right to development, even if he had the right to life ensured. And what about the child's dignity, which is kind of an underlying value of the whole Convention on the Rights of the Child? So at least I think these other rights come into play in a situation like this. And of course, all of these rights should be examined properly before you can reach a conclusion. You cannot just say, I've done it very swiftly, sweeping. But when you have several rights like this, you have the right to life, but you may also have other rights. You need to examine all of them, but when they don't give a solution, that is when you can turn to the best interest of the child's principle, or the right, as I would like to call it. And I think it's much better to talk about the best interests in that situation than to start talking about public resources, for instance, which would easily be the case if we didn't have this principle that we could use, which would direct the thinking towards the situation of the child. Best interests also have got a lot of attention in child protection. There's the right to protection under Article 19, there's the right to care that I just mentioned under Article 3, number 2. And so in child protection cases, I think all of us know that you cannot go directly to a best interests consideration or assessment. You need to first establish what are the rights, or I mean, mostly they are put into legal criteria in the national laws. But it's the right to family life under Article 16 and not to be separated from the parents under Article 9, number 1, which would also be of interest and really important in child protection cases. And so all of these have to sort of be weighed, and if you find that they don't give a proper solution in themselves, then it's possible to turn to the best interests principle. So I would like to say a little about the contents. So now I've tried at least to talk about when to use the best interest principle, and then to its contents. In the best interests assessment, each and every aspect of the child's circumstances, it's the child's characteristics, the situation, and the needs of the child, just to put it broadly, must be looked into, and they must be examined properly. I mean, it's not that you just put your finger into the air to see what way the wind blows, or you throw dice or something, or you just use your personal values. You have to look into the child's situation. This is the starting point. It should be an individual case-by-case examination. I think this is the really great thing about this rule in Article 3. Number 1, that it puts the child at the center of the decision-making. And also that it says that it has to be, facts have to be established based on the specific situation of the child at the moment, and with a look to the future, of course. It is a discretionary concept, but it's not as discretionary and as vague, I would say anyway, than as it is sometimes claimed by people. But the need for guidance is also why the CRC committee, of which I'm a member, produced General Comment number 14. It was precisely because people out there who are going to use this principle in practice thought it was really, really difficult to apply. And this is a comment to the discussion yesterday about principles versus somewhat more specific guidance. And I am in no doubt that people need more specific guidance. Maybe not in detailed rules, but at least some guidance as to how to apply a principle like that, and Article 12 for that matter. Yeah, I think a final point when it comes to the contents of best interest is a good point made by John Ekelar quite some time ago, to choose the solution which can more easily be changed at a later stage in the child's life, since the child develops and changes. And you may say that is an argument that goes against the solution in the Charlie Gard case, because that is really when you cut off life. There's no more possibilities. If you keep life going, maybe there will be some cure that might someday turn up. This is at a general level. In that case, it seemed there was really no hope. That's at least my reading of the European case. I would like to finally say a little about the child's views into all of this. the relationship between the child's views and the best interests. So it's the right to be heard and the right to have the best interests considered. And best interests have been accused of being a paternalistic concept. But the more weight you give to the child's views, the less paternalistic it becomes. It's kind of, this is a way of including the autonomy of the child into the best interests principle. So you sort of take the best interests seen from the outside, and then you include the child's autonomy seen from the inside, and you try to make the best of all of this. And one could take, as was mentioned by Helen yesterday from the book she talked about, you could take the child's views as a starting point and say that they should, the decision that the child wants, if the child wants a specific decision, should be chosen unless there are strong arguments to the contrary. This has also actually been the position of Michael Freeman since many, many years. I think, anyway, it's important to say that adults have the final responsibility for the decision to be made, because it's also, it's very stressful. It may be very stressful for the child to be left with the responsibility for the whole decision. And I think the child does not necessarily need to have his or her ways, I mean, to have his views being the decision, as long as he or she is explained why the decision was a different one, so that the child is taken seriously. The CRC committee has said that children are able to form views from the earliest stage. And that's an interesting issue, because can you actually take the child's view as a starting point when the child expresses the view through body language, through play and so on? Well, it depends on the situation. If you can actually say that this is a kind of view that the child expresses, maybe it's possible to take it as a starting point. But I think taking the child's views or wishes as a starting point is maybe more relevant when the child is somewhat older and can express verbally what the child wants. But this is up for discussion, I would say. In the case of baby Charlie Gard, a guardian was appointed to sort of give or represent the child's views, which I must admit I think is a rather odd way to do things, because it's not any easier for this guardian to find out what is the baby's views than anybody else involved in the case. Anyway. I wanted just to this is my final words actually, to say that, or to repeat that I don't think the best interests is as vague or as paternalistic as it is, or it doesn't need to be. I mean, this is up to each and every one that uses the concept, but they should follow what is actually, well, actually in Article 3, number 2, it says that it shall be a primary consideration, and then there is some guidance out there to be found, and I think it's at least good to use that guidance and not let it trump rights. Thank you. And I was allowed some more time than 10 minutes actually.
It's true, yeah. Thank you very much, Kirsten. Asgeir, do you want to go next?
No. Kind of not a question, is it? Hello, you can hear me. I want to just start a little bit shamelessly and just plug my book. I edited a book with a bunch of scholars here in the room. It's called Human Rights in Child Protection. It's about rights and its implication for professional practice and policy. So it comes in September, and it's kind of very relevant to what we have been talking about these 2 days. It is also on the website of this center. So thank you. Thank you for the speech. Today I will talk a bit about some theoretical aspects pertaining to the best interest principle. And it is an understanding that I think could bring in a way to use the principle actively in decision-making designs, in developing educations, developing policies, and which kind of talk to the use of the best interests principle in the casework that follows in child protection cases, and it's used in care orders and such. So, welcome back to political theory. To understand a system of human rights, it is useful to apply a theory of rights that capture what individual rights are and what they do. Many such theories lay weight on the individual freedoms that human rights protect, and which stand as a guarantee for any person to choose a rational plan of life and act upon it. To any modern liberal democracy, personal liberty must be presupposed to all as a matter of right. A principal right to liberty is embedded into the constitutional architecture and structure that structures the legal form, the democratic legal form, making sure that law can be legitimate and understood as legitimate by citizens. This is basically a Kantian insight, and it states that law cannot unfairly infringe upon a person's liberty without threatening the principle of personal liberty altogether. Hence, the right to personal liberty must be safeguarded before any other rights, and especially legal, political, and social rights. The very validity of laws is dependent upon laws not infringing upon the personal right to freedoms once laws become positive. The legitimacy therefore becomes dependent upon being interconnected to its claim to uphold the fundamental right to liberty on one hand, and not having consequences of impeding freedoms upon implementation and enforcement through, for instance, professional practice in child protection on the other. As adults can fully make use of their rights and act positively on them in all matters, children becomes a special case. Although they have inherent rights to all freedoms by virtue of their humanity, they are not always capable or allowed to act upon freedom. Nor should they carry the burden of responsibility before they can be fit to make their own choices. This is kind of, this goes back way, thinking about how children are to be included. When parents violate the child's negative right to liberty by providing detrimental care, the state must intervene in loco parentis, not only to make sure this does not continue to happen, but more importantly, safeguard that the development of the child is returned to a developmental track in accordance with the child's own development trajectory. What the child would want, its interests. Hence, repairing the damage to the child's integrity caused by detrimental care. The goal, then, is to continuously work throughout childhood so that the child eventually can act upon a basic negative right to liberty once adulthood ticks in. As this is the continuous job of child protection services, or that is the claim, we can capture a central tenet within child protection services to be the protection of a child's prospective right to liberty. The prospective right to liberty not only has consequences for how a childhood should be protected with regard to the future adult, but also how childhood is in need of protection according to the current needs of the child. The current needs of a child are continuously what feeds into the development of the child, and infringements upon its needs could have long-lasting effects if not mended. Hence, it is imperative that the quality of care during childhood is not to the specific child's detriment, either in the here and now or in the future childhood. Hence, decisions in the best interest of the child must look far ahead into the future of the child. If the child does not live a childhood free from detriment from moment to moment, the development will incrementally become stifled and skewed, and the individual child's ability to explore and develop as a person becomes impaired. The prospective right to liberty can therefore be a rights-based corrective for the role of child protection and decision-making, and to push the child back on track so that development towards adulthood is what the child itself would want, that is, according to the child's best interests. This line of thinking could, for instance, have consequences for in-house follow-ups in child protection, follow-ups in foster care, in institutions, and it could also set demands towards decisions in the here and now that commits service officials to make sure the child is all right also in the future. It actually alludes a lot to what Kirsten just ended her speech with. Most importantly, though, it could inform education that you are not are not done with a child before the child enjoys access to liberty on par with others alike once adulthood takes in. Thank you.
Good morning. Allow me to start with a spontaneous personal comment. I just realized where we met first, Kirsten. It was at the Committee of the Rights of the Child you chaired in Geneva, and you asked me the question whether the term for child's best interests in Germany causes difficulties or if it loses something. In Germany, we call it Kindeswohl, child's well-being, not child's best interest. And I was caught by that question. I was caught by surprise by that question. And I gave some answers and saying, well, I don't think so, as a conclusion. But this question followed me as a layer of thinking since then. In all my reflections on child's best interest under the term Kindeswohl, I always think, is it losing something? So thank you for your impact on my personal thinking. So I want to, but that for a start, spontaneously. But yeah. When entering the field of the child's best interest, we're entering the field of the relationship between children, parents, and the state. Who defines what is in the best interests of the child? This is the question that's hanging in the air throughout when we discuss it. And we're facing children who are in a paternalistic basic situation. It means, let me introduce a triangulation. It means it is a developing child. The child has growing ability to self-determination and has a growing need to self-determination. But the child has a right to be cared for, has a right to paternalistic actions, to have its best interests defined by someone else. So the child is dependent, less so when growing up, but the child is dependent and has a right to its best interests being defined by someone else. And the child is not only a developing child, it's always a competent child. And the child's view that, a baby's view that he or she is hungry, the child usually can express pretty well, for example. The child knows what she or he wants. Just ask your son, he'll tell you what he wants and what he doesn't want. So the child is always not only a developing child, it's always as well a competent child. And thirdly, the child is a child in need of protection. And that, giving you an example, a toddler that wants to climb a chair, you can say, oh no, don't do that. That's dangerous. And it might be. Or you say, okay, let's see, try. I'll be at your side. If you stumble, I'll have you. So the child is in need of protection. That's the third layer. And they all combined. They're not strictly divided. They're all intertwined. So that's the situation, the paternalistic basic situation when entering the arena of child's best interest and the child's best interest in principle. So defining what's in the best interest of the child has challenges, has caveats, and maybe some solutions. we always should be a bit hesitative to say we know what's in the best interest of the child. That one reason is that it has a limited predictability. Oscar mentioned that particularly yesterday. The development often does not allow to predict, to make a prognosis what will be best for the child in the future. For example, if you appoint after separation both parents with shared custody or with sole custody for one parent, you cannot tell today what will work out best for the child, usually. There are some cases when you have an idea or probability, but sometimes you don't know. You don't know how life will develop of all the persons involved. So, and then it always has a remaining uncertainty. You're looking from outside into the life of a person, and you don't know how close you got to what her views are, what he or she thinks, and what her situation is. So there always remains an uncertainty. For example, did the girl or the boy give consent, sexual consent, in that situation? The answers you get might get you close, but you're not. There are a lot of cases where you can't really be sure how it was. That's just one example. There are many, and we're in a field of uncertainty. We have to live with it, and we have to find a way how to handle it. And then the high value of the child's best interest sometimes leads to a transformation of adult rights, claiming them to be in the child's best interest. For example, foster parents, in many cases, if they say what their interests and what their needs are, they're not heard. You're here to care for the child. It's not about you, it's about the child. That's what they very often hear, so they say, it's in the best interest of the child that this or that happens, but no, it's in my interest that there's not contact 5 times a week. I can't be at the service of 5 times contact or almost every day, and I have my personal life as well. Does that count? Does that not count? Or is it? Do they have to say it's not in the best interest of the child? So we need to be careful what we're talking about when talking about the child's best interests, because the higher value of it leads to a transformation of other interests into it, because otherwise they're not heard. And all this unclarity, you called it vague, might lead to a wishy-washy situation, this perceived wishy-washy, you don't know what it is. And therefore, many of the legal scholars, and I think that's pretty convincing, the child's best interest gets a concretion in link to a concrete right of the child. The right to be heard, for example, or the right to play, and so on. So in connection with those rights, it gets a concrete meaning. So that leads it out of the vagueness and helps us to get closer on when trying to define the child's best interest. And and then the last point I want to make is how do we decide in cases of conflict? Do we always decide in favor of the child's best interest? As Helen cited the book, we should listen to the child and always do what the child says, a radical position. Well, first, a German translation of the CRC. The German translation says there's a primacy to child's best interests. Vorrang des Kindeswohls. Well, the original language is a primary consideration. That's slightly different. A primary consideration. So, and a primary consideration needs to be negotiated with other interests and other rights. And children live in relationships, and in relationships it's not just one person whose right will come through. It's negotiation between the persons in the relationships, and with children, sometimes it's been been made for them. No, I don't want to come with you on holidays. Oh, yes, you do. No, I don't want to visit Aunt Mary. Oh, yes, you do. So there are decisions being made for children on everyday basis. So, and we don't ask, is this in the best in every decision we ask if it's in the best interest or not. It's relationships, and sometimes we have to do what others in the relationship want to do, and not only what we want to do. Okay, and I conclude with a citation of the Canadian Supreme Court. I think we should, a primary consideration could be phrased as a substantial, we should give it a substantial weight and be alert, alive and sensitive to the best interests of the child. I think that's a very nice phrasing, and that will be my concluding remarks. Thank you.
No, I will speak from here, so please commentate. Okay. Yes. Good morning. I was asked to summarize what the others have said and perhaps then reflect on these ideas. And I would like to start off with a personal anecdote. Those of you who are parents, I think that you have physically felt the shift from personal autonomy towards the rights of the child and the importance of the best interest of a child. At least I did when my first son was born. 1 month after that, after the birth, I realized that really my rights don't matter at all. My autonomy is so subsidiary to the ones of the child and to the needs of the child. So this is perhaps then the background of my thinking, and I will first summarize what the others have said or what I picked up from these speeches, and then perhaps bring in some food for thought. Kirsten started from discussing the relationship between the best interest and other rights in the Convention. And I think that this is a very important starting point, that the best interest is not alone in the Convention. It is a question of relationship between different rights and then finding the correct balance and finding the best interest within it. And she then turned to the substance and defined child best interest as being in the center of the decision making, and also stressed on the importance of children's and particular child's views. But she also said that us as adults have the final responsibility. I would presume that this is the place where the prof we heard yesterday would perhaps come in and say that's not always, that this is, relative, but that they want to take the responsibility themselves sometimes. But I mostly agree with this kind of view that someone has to bear the burden of responsibility, bear the burden of decision maker, and it is very difficult to put this burden on the child. Oscar then brought us back to the human rights theory. Thank you for that. I think that we get perhaps too fast engaged in this kind of itty-bitty of legal talk. And you stressed the importance of right to protection on the one hand and liberty as important concept on the other hand, and finding this balance between these different values was, I think, for me, the key from your speech. And Thomas brought us back to, or closer to what my intervention will be about. And you talked about the different layers of rights and the complexity the child is living in, and the importance of grasping this complexity and then finding this correct balance within this complexity, looking both to the future as well as the realities of the children's life. And from your talk, I think the balancing exercise, or the importance of finding the elements that one balances, was perhaps something that was most strongly present. But my intervention relates more to the universal characteristics of the CRC and to what extent we really globally understand the principle of the best interest of a child uniformly or similarly. You brought out the German term for the best interest that does not reflect precisely what the convention says. Well, I have 3 more examples. First, I come from Estonia, and in Estonian translation of the CRC, we have lapse huvid. This means interests of the child. In English translation, they translate it as the best interest, hiding behind the language. But when you see what the courts are doing in different child protection cases, or also child best interest is a wider concept, it should also be considered in the policymaking procedure, how the policymaker is evaluating the interest of the child. They are not looking for the best. They are looking at some interests, disregarding others, selecting what seems to be perhaps important in the case, but quite often you don't see this kind of full-fledged balancing exercise being performed. In Finland, the term is closer to the one that is present in the CRC. It's lapsen etu. It is not precisely the best interest, but it is close enough. It has the connotation of the best within it. And when you see the national court practice or the national practice of different bodies in Finland, you see that they are trying to find the best. They are trying to look for different solutions for different values and balance them against each other. Well, Russia is my 3rd example. Законные интересы, legal interests of a child, is the translation they use in their national legislation. And of course, who is defining the legal interests? Well, the government is. And do these legal interests reflect the best interest of a child, or at all the varieties of the interest of the child that one should look? Well, of course not. For example, it is a legal interest of a child not to be exposed to gay propaganda, because children need protection. Well, so my question perhaps then to the panelists and the thing that I have been wondering is how much national interpretation, how much difference in the interpretation does international law allow? Do we accept that every country will translate the convention into their own language and their legal practice, and then would apply their version of the best interest, whatever it is? Can we, on the other hand, avoid it? I don't have the answer. Perhaps this is something that we can discuss. Thanks.
Okay, thank you so much for that, Katra, and also to Thomas and Asgeir. Malcolm, are you surprised from Malcolm again? Okay, yeah, that's okay. Yeah, it is. Yeah. Okay, then we'll do the questions first. Yeah.
No, the mic will come.
I just found those contributions really incredibly helpful, and I think I live in this world the whole time, so thanks a lot. A couple of points I pick up, I think it's from Kirsten, about maybe it's Oscar, the child in trust. That the child's welfare does change and the child's wishes change. So if you make irrevocable decisions, then you don't allow you don't keep the child's welfare in trust so that the child can subsequently come back. I'm talking about a country that uses adoption very extensively. And therefore, in England, it is a paramount consideration, not the paramount consideration. And you've all made that point, really. And I think it's unfortunate when it becomes parents versus children, because children have a right to parents, and parents have human rights, and adopters have rights. And at the moment, there's now a tension, and the judges are taking one position around adopters' rights or prospective adopters' rights in terms of contact. Does the child's right, interest, indeed wishes to stay in touch with the grandparent he's been living with for 3 years? Does the adopter's wish to have a nice, tidy no contact adoption trump the obvious child's wishes? If you ask the 3-year-old, do you want to leave this grandparent that you love and go and live with somebody else who might give you a family for life at the cost of losing the grandparent that you love?
All right, so thank you so much. I have a few questions and maybe slight comments. So I think one of the questions is the philosophical understanding or theory of rights that we use when we talk about the children's rights. And so when rights were presented as, trumps in the kind of liberty traditional sense, it seems that relational autonomy and relational readings of rights, like Nadelsky type, would be exactly the right type of framing when you talk about rights in general, but specifically when you talk about children's rights. The second point, I think, is that, the enabling conditions for rights. So when you talk about children's rights, you're immediately talking about a right to care, and that then imposes duties of care on those who hold responsibility. So I would say that it's not just a question of them having rights. So I, also have a rights. Your rights holding status does not cancel me totally out, although this is exactly how one experiences maternity, I agree, at least in the early stages. But it's also a question of enabling conditions. I mean, so I don't know whether I told myself as a mom because it would make me feel less selfish, but I basically felt I could only provide good care if a certain minimal conditions of well-being of my own were met. So I wonder whether the enabling conditions notion plays any role in this conversation. And then finally, in terms of autonomy, how much, because I haven't been following from up close the debates on children's rights, how much developmental psychology theory is taken into account, especially when it comes to autonomy, notions like autonomy. I always have a wonderful example of my personal life, which is 15-year-old, 16-year-old friend of mine in Belgium. I come from southern Spain. And I would spend holidays with her. And she was allowed to bring in all her boyfriends. They would just come in and out the door, everything very civilized, very friendly. Now, for me, this was just mind-blowing, right? Many years after that, I remember bringing that up as adults as a conversation and saying to her, wow, you had such a liberal education, your wishes were always respected. And she told me, I felt that my parents couldn't care less about what I was doing. So the idea that the limits and having limits is part of a necessary ingredient of the autonomy formation process, I think is an interesting concept from developmental psychology, and I don't know how much that is discussed. Thank you.
Is there any more questions? Anyone want to go?
Yeah,
I can start. I would like to, sorry. To start by your question, actually, how much national interpretation do we allow? And the Committee on the Rights of the Child is quite eager that there's not too much national interpretation that deviates from really the best interests concept as it is, I mean, in Article 3, number 1, and then further elaborated in the general comment. And I guess this comes out of the comment that you made from our previous meeting. Now, of course, I remember when you told me, yeah. But it's difficult because it's also a language issue, and it's difficult for the committee or for anybody outside the language that don't speak the language to actually know what the various interpretations or translations of the concept mean in the different languages. But it's something that I think we should work on in each and every country, probably. Yeah, I didn't really set out to speak about the child's or the best interest of the child versus other rights or interests, because I felt the introduction in the thing was very much focused on the concept itself. But we have a lot of discussion in Norway about the children's best interest being a primary consideration, and that is something I think we're just going to continue to do. But when it comes to children versus parents, I think it's better to put it in the way of being the paramount consideration, like the European Court of Human Rights actually does. I think that's interesting. They go further than the Convention on the Rights of the Child, and that's because the parents have to kind of accept that they have put the child into this world, and the child's rights and interests must be paramount to their own. Thank you.
Anyone else want to respond to the...
I agree to the paramount concept when it comes to conflicts of adults. In conflicts between adults, especially, or that really leads to a view that focuses from the child and takes a look at that situation, because that might get lost when adults are in conflict. So I very much agree on that. And what you said, June, about whose rights are in play and how do we handle that? I really like the concept that we see that it's the individual interests and rights of persons involved, and take notice of them in our decision-making processes, in our assessments and evaluations, and not meaning that giving them more weight, but when balancing them, you use the term balancing, when balancing them, we need to see them all as they are, and who is not just seeing framing it as is it child's best interest or not child's best interest? Who has what interest, and then balancing, and then go to the paramount consideration. Then we can go that path if we've seen all the other interests that are in play. And when it comes to autonomy, I from an ethical point of view, I like the concept of hedged autonomy. In childhood, there's a lot of coercion you have to do. You have to brush your teeth every evening. It's not your freedom to do it or not to do it, and you're limited to 1/2 hour of TV every day. So there's a lot of rules out there. But it's hedged, and the autonomy and the growing ability and need to self-determination can be felt much better if the space in between those broadening hedges is made visible for the children, and this is the hedge, but in between, that's you. What do you want? What is your part? Well, we have to take you in care right now, but you can decide what you take with you. We listen to you. What would be best for you? What in this situation? What you could be best for you? What do you want to eat? And so on. If we really talk to the child and see, let the child, even in those very critical situations, have a say, and being taken into account what the autonomy is, and so the child can feel there is some self-determination left. So I like this concept of hedged autonomy.
Yes, very shortly to the last point, not precisely answering the question, but perhaps then stressing the importance of experts and psychology and developmental theories, as well as understanding of the medical, as well as all diverse needs of the child. This is not usually a legal decision purely, but it is very much dependent on experts and their opinions and their evaluations. So in the court proceedings where you see the discussion on the best interest of the child, especially in the removal cases or in this kind of more extreme cases, you see that this is not a legal question as much as perhaps what the theory on child development, child psychology would guide us towards. Thanks.
Have any last comments?
I need to talk. Need to say something. It's just an anecdote, but the Polish draft on the convention in the late 70s actually had Paramount put into it. So it was omitted because of the nice Americans that didn't sign it. so we ended up with primary consideration. But just fast to this about how much leeway is it to the nation state and implementation of the convention. And I think, for instance, in the Norwegian case, that we just said we are in legal harmony. We just did it. And the thing that I find odd about it is that in the legislative history to those legal rules that stipulates the child's best in child protection, it doesn't reference the Convention on the Rights of the Child or human rights at all. So it needs to be kind of the development of the legal rules that kind of put in the Convention on the Rights of the Child into effect needs to be filtered through an understanding of human rights and take this cosmopolitan turn, so to speak, nationally. If not, we have the discrepancies from country to country will be too great. Sorry.
Okay, so thank you all of you, and thank you for your questions. Maybe you can't hear me.
Sorry.
Yes, thank you.